Whoa!
I filed my eligible obligation.
What are you talking about? What are you talking about?
I'm talking about eligible obligation.
What?
On the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh.
That's enough. I don't want to hear another word.
Okay, I'd like to also.
Another one? I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush.
All right, folks. Today's case involves a self-proclaimed sovereign citizen facing a possible 30-year prison sentence. Yes, 30 years, and instead of hiring a qualified attorney, he chose to represent himself. Whether it's a case of extreme overconfidence or simply not caring about the outcome, it's hard to say. What we do know is that things don't go well for him in court. The judge quickly puts a stop to his arguments, and the situation spirals into one of the more chaotic courtroom moments we've seen. It raises a serious question. Why would anyone choose this approach when so much is on the line? Let us know your thoughts in the comments. Okay, now let's take a closer look at how it all unfolded.
All right, Mr. Baker, you're before the court day for your arraignment. And let's see. You're not. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish
Yes,
to have
sir.
a public defender to represent you?
No, sir. I'm representing myself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Well, it's hard to understand how someone can sit in front of a judge, be told they're facing 30 years in prison, still respond with, "Yes, sir," while sticking to a completely discredited legal argument. Sovereign citizen defenses are known to fail again and again in real courtrooms. Using that kind of logic for a minor traffic ticket is one thing, but when you're facing decades behind bars, it's time to take things seriously. The courts do not recognize these made-up interpretations of the law, and legal precedent has firmly rejected them. Yet here we are, watching someone risk everything possibly out of pride or complete misunderstanding. Do you think he's genuinely trying to outsmart the system, or is something deeper going on? Share your thoughts in the comments seam. Really curious to hear how others see this situation.
If you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business,
All right. What kind of business?
a cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to
No, sir.
to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
Comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, and you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions.
Yes, sir.
You have copies for the state.
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's the declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk.
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk. The declaratory
Anything you
judgment-
file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess
I
up.
understand that.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're innocent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir?
What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. And if I hear it again, I'm not going to let you represent yourself. I promise you.
Well, he just mentioned USCA, stands for the United States Code Annotated. It's essentially the U.S. Code, but with added notes and explanations from legal publishers. Now, let's be honest. It's unlikely he actually understands what that means. People like this often throw around complicated legal terms as if saying the right phrase will somehow get them out of trouble. But that's simply not how the legal system works. Then there's this idea of eliminating obligations, which is another false belief some think they can erase criminal charges like overdue parking tickets. Courts across the country have consistently ruled that these arguments are completely baseless. Yet here he is, acting as if he's uncovered some hidden legal loophole. What do you think? Is he genuinely convinced by these theories, or is he just trying to confuse the judge and buy time?
He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for a... Don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December... When's that motion day in December? December 19th at 9 o'clock. Sir, you may... If you're going to do the sovereign citizen and all that, you may want to consider having the attorney...
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
We'll see you December 19th at 9 o'clock.
It's no problem. Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also...
I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him or he gets in any more trouble.
To be honest, I think the judge may have done this man a real favor by removing him from the courtroom and ensuring he received proper legal assistance. Some might say the judge came down too hard, but what were the alternatives? He couldn't just sit there and let someone go on about completely unfounded legal theories while the court's time was being wasted. Instead, the judge stepped in and said, "Enough. If you won't take this seriously, we'll get someone who will." And frankly, we need more judges who draw that line. There's a limit to how much misinformation the court can tolerate. Many of these individuals rely on online forums and conspiracy theories, thinking they've found a loophole that makes them immune to the law. But a few more minutes of honest research would show that no sovereign citizen argument has ever succeeded in court. The judge in this case was patient, even gave him a chance to reconsider whether he wanted to keep going down this path. Sadly, it looks like he's just doubling down. What do you think? Did the judge handle it the right way? Or should he have let this go on longer? I'd love to hear your thoughts in the comments. And if you enjoy courtroom breakdowns like this, 1. Be sure to like and subscribe for more. Thanks so much for watching. Take care and stay informed.